So I am Jaden Cramer. I'm going to be speaking about sexual harassment in the workplace under the Equality Act. So why this is important at the moment is the Worker Protection Act, which has been spoken about, has amended the Equality Act to introduce a preventative duty on employers to take reasonable steps in employment. So it actually goes beyond the workplace, and it's in employment. And it is in addition to all the new duties, which is quite important. It doesn't take away, it only adds to. What do we mean when we say in employment? This covers workers and employees. It covers employers and service providers. It also covers everything from the recruitment process, so the way you advertise, the way you recruit, the terms and conditions that you offer employees, the training and promotion of employees, conduct during employment, and then the more typical examples that you'll find, conduct at work-related social events. In terms of what the Act currently prohibits, harassment can be broken down into three components. It is harassment related to a relevant protected characteristic, sexual harassment, which we'll speak about, and less favorable treatment of a worker because they submit to or reject sexual harassment or harassment related to sex or gender reassignment. So these are the relevant protected characteristics. So for some of you who are familiar with what the protected characteristics are, you'll notice there are a couple missing. And that is because pregnancy and maternity, marriage and civil partnership are not relevant protected characteristics for purposes of harassment law, which is something worth noting. Harassment is defined as unwanted conduct related to a relevant protected characteristic which has the purpose or effect of either violating someone's dignity or creating an intimidating, hostile, offensive, or degrading environment for that individual. Sexual harassment has the same effect, but it is of a sexual nature and includes almost everything. So anything you can think of, from the typical physical and verbal to the non-verbal, and even things that people would not necessarily anticipate, like the unconscious biases that we have in the workplace. Importantly, something that is often overlooked in terms of this definition is the purpose or effect part of it. And the reason this is important is because what it essentially says here is that intention or lack of intention is irrelevant. It doesn't matter whether you intended to create a hostile environment. Even if you didn't create a hostile environment, that might not have the purpose or effect and meet the definition. On the counter of that, if you did not intend to create a hostile environment and you did, that would constitute harassment under the definition. So your intention or lack of intention is completely irrelevant. Why is this important, and why do we speak about this in the legal terms, and what are the legal liabilities that come with this? So obviously, as employers, every employer should be aware of the vicarious liability that you can suffer for the acts of your employees. So you should really be taking a proactive approach to this, even without the legislation that's been brought about. It covers, as we've said, everything in employment from the beginning of an employment cycle all the way to the end. It doesn't matter whether the acts were done with your knowledge or approval, you would still be held liable. One of the only ways that an employer can escape liability is if they can show that they took all reasonable steps. And that is what is known as the statutory defense, Section 109. And that is not to be confused with the all reasonable steps that will be coming into effect next year. All reasonable steps essentially means that there were no further steps that could have been taken. It's an extremely high threshold. The other very important and overlooked part of this is that most people don't know that they can be held personally liable for sexual harassment. So if a tribunal finds that there is compensation due, you could be personally liable and your employer can be vicariously liable. There are two separate liabilities. So the preventative duty, as it's become to be known, is the duty to take reasonable steps to prevent sexual harassment in the workplace. The duty requires employees to take reasonable steps to prevent sexual harassment by their own workers, third parties, which is everyone from service providers in the typical sense, all the way to friends, family. And if you think about the way that we work these days, working from home, you can see that there are instances where friends, family, those kinds of relationships, even in a more typical sense, not in a work-related social event, could become an issue, and agents acting on behalf of the employer. So what is different about the preventative duty? Why is it called the preventative duty? It is an anticipatory duty. Employers should not wait until there is an incident of sexual harassment. They should actively take steps to anticipate and prevent sexual harassment in the workplace. Where there has been a successful sexual harassment claim, the employment tribunal, and this is important, must consider whether and to what extent the preventative duty has been breached. And if the preventative duty has been breached, it could be a 25% uplift on any award. And these are generally uncapped compensatory awards. So it's not a standalone claim. So you would have to found harassment and there would have to be compensation awarded for that harassment. But if there is harassment found and compensation is awarded, 25% uplift of a potentially uncapped claim. And as mentioned by some of our other speakers, the EHRC can take its own action, including all the way up to an injunction in the most serious cases. What is reasonable depends on every employer. Mom and pop shops are not going to be treated the same as mega corporations. It looks at the size and resources of the employer, the sector it operates in, the working environment and the risks present, and also the type of third parties that the worker has contact with, the frequency and the environment. So someone who is a bartender is not going to have the same risk profile as someone who works in a more typical environment or an office environment. What is reasonable depends on the particular steps that you've taken and whether alternative steps could have been more effective. So you can't just go to someone who said, oh, we did this, and just apply it as a blanket approach. You also have to look at the time cost and potential disruption of taking particular steps, weighed against the benefits it could take. So you really have to think about what is the benefit that we could be achieving with a step rather than just taking the step. And when concerns have been raised, you have to take steps. We don't have time to go into a whole expose of the employer 8-step guide that the EHRC has provided. And this is probably seen as, at this moment, as what most people would consider to be the reasonable steps that employers can take. It would be very unlikely to take one of these steps and for it not to be seen as being reasonable. As mentioned, the Trust and Blake Morgan have partnered to create a built by design training, and what we believe is the cornerstone of the reasonable steps are 1, risk assessments, and 2, training. There is no case that I can think of where you have done risk assessments and training that it wouldn't be seen to be reasonable. So definitely a resource to look at and definitely worth having to hand. Further developments and future developments, as already touched on by some of our speakers. So the Employment Rights Bill was published in October 2024. And in the context of sexual harassment, the bill states that the preventative duty to take reasonable steps will be amended to take all reasonable steps. Again, we are not sure what all reasonable steps are at the moment. It is extremely broad. So for example, if you take 1,000 steps, if there was one more step that you could have taken that could have been seen to be reasonable and you didn't take it, you could fall short of the preventative duty. So it is an extremely high threshold. The bill also reinstates protection from third-party harassment, which was done away with in 2013. And as mentioned, whistleblowing protections will be extended to apply to disclosures relating to sexual harassment, and they will be added to the current list of protected disclosures. That is extremely important, particularly in my field, where we see a lot of settlement agreements where, as was mentioned, employers escape liability and the negative connotations surrounded with the actions of their workers by just paying someone off and signing a settlement agreement. Lastly, while we have these things on the horizon, while we have the reasonable steps, it's always important to go back to what we've always had, or what we've had for a long time. There's always been a legal duty to ensure, so far as reasonably practical, the health and safety and welfare at work of your employees. I mean, it's simple, right? You know what needs to be done, and you should be doing it. In terms of your contracts of employment, there's an implied duty to provide a safe working environment and safe systems of work. There is also an implied duty of trust and confidence which should not be breached. Breaching any of these, aside from any of, well, the specifics, if it was sexual harassment, the awards, the compensation, the uplift, could also result in a constructive unfair dismissal, which is also a huge potential liability for employers. That is all I have time for. It's obviously a very broad section, but hopefully that's been helpful.
Thank you so much, Jaden, and to Blake Morgan. That was a really comprehensive overview of the legal framework. I think really helpful probably for many people in this room, and particularly around the liability and that two-person element to that personal liability. And I think it's really interesting just to note in terms of that preventative duty and the active steps that can be taken, particularly that focus on the training and risk assessment. So if you haven't already, please do take a look at our website, and there's some more detail on some of that training available.